21-14-8316. This is Discover Bank versus Shuri Fry. Matter is before the court, set on for a hearing on a motion for summary disposition. Your appearance for the plaintiff, Discovery Bank, in this matter, please.
Yeah, good morning, Your Honor. For the record, William Saloom, P41487, appearing on behalf of Plaintiff Discover Bank.
All right, thank you, counsel, and good morning to you. I'm looking now for Mr. Shuri Fry, last name Fry. If you want to assume, please say something at this time.
I'm Mr. Shuri Fry.
All right, thank you, Mr. Fry, and good morning to you as well, sir. This matter is brought on the plaintiff's complaint in this matter, alleging that that there are damages as a result of the use of a car by the plaintiff Discover Bank, and it is alleged that the balance outstanding is some $14,583.34. Plaintiff has brought a motion for summary disposition and for judgment on the complaint. The court raised those issues at a previous hearing, and the court did review a responsive plea that was filed in this matter. Filing was on or about July 7th, 2020. Counsel, this is your motive. That's right. This is your motion on behalf of Discover Bank. You may proceed at this time.
Thank you, Your Honor. Your Honor, our motion basically is just indicating that the defendant in his responsive pleading has not raised a triable issue for the court. He's pled only general denials or even an acknowledgement of the debt. And therefore, as a matter of law, judgment should be granted. We've, I think, attached the statement of the account and the monthly billings that went to Mr. Fry. And I haven't received anything that has put into doubt that submission. So I would ask the court to enter judgment as a matter of law.
Right. Mr. Fry, I do not see where you filed a written response to this motion. You did not do so. Is that correct, sir?
Yeah, I called. I got a number. I was on the assumption that I can call this.
Let me stop you for a moment. On the specific question that I raised before you, the question is, did you file a written response to this motion for summary disposition?
No, I didn't. I didn't. Hold on. I didn't get a.
Wrong approach. No, hold on, not the judge.
Okay. I'm sorry. Okay.
I've heard you in that you did file a written response. You were communicating something else to me that you took some other actions. Tell me about that.
Okay, I was on the assumption that, and I apologize for asking you to hold on, but I was on the assumption I'd come to the court at this date and we could talk about it. I'm eligible for my pension because I'm 61 and a half, and I'll have a income stream mid-March, and I wanted to have a delay on this so I have the ability to pay on a monthly basis.
All right.
Because right now I'm still looking for work.
Sorry. All right, Mr. Fry, why don't we do this, counsel? Why don't you take a moment? I'll send the two of you to a breakout room and see if you can get this worked out.
Yes, Your Honor.
It's about some type of arrangement to try and take care of this. That's probably something that can be worked out. So, Mr. Fry, I'm going to give you a chance to talk privately directly with with the plaintiff's counsel about those issues, and then I'll come back and I'll address the motion. Perhaps you all finally reach some type of consent together with an agreement regarding payment. Maybe that works out. I'm gonna let the two of you talk first, and then you come back into the courtroom and we'll go for it.
Okay.
So you're going to receive a notification to go to breakout room number 1, and getting that right now. Just click in once you receive that. Likewise, comes there you are.
Yes, thank you, Judge.
Thank you. All right, this is case number 21-160-656. This is Cornerstone Community Financial versus Alicia Langford. The matter is before the court on the filing of the motion for summary disposition. The record should reflect that this matter arises out of the complaint alleging that there is a past due balance relative to an agreement to purchase an automobile. That there is a balance of $10,116.33. The court did receive an answer to the complaint in this matter, and the plaintiff ultimately filed a motion for summary disposition. Your appearance for the plaintiff this time.
Your Honor, Michael T. Mamet, P. 1102 on behalf of plaintiff.
All right, good morning to you, counsel, and thank you
Good morning.
for being here. I'm looking now for Ms. Langford. Ms. Langford, if you are on Zoom, please say something at this time. The record should reflect that the matter is set on at 9:30 a.m. It's now 9:50. I'm looking for a Ms. Langford on Coleman Street in the city of Detroit. The record should reflect that court did send out a notice dated December the 1st, 2021, sending the matter over for hearing on today's date. That notice went to the address provided in the court's file for Ms. Langford. That's 8141 Almond Street. Record should reflect that here's what I'm seeing, counsel. I'm seeing that in her answer, she puts an address on Cushing Street in East. Probably
East Point.
Yeah, we probably should have sent it notice. I can give you that address. So, we probably should have put that address on the notice. So I'm likely going to re-notice this to actually use the address that the defendant provided. And that is an address on Cushing Street, Cushing, 22752.
All right. Will the court be sending that notice?
Yeah, we're gonna send that. We're gonna send that notice out. I know that when the litigation was started, it addressed Almond Street, and I know that there was proof by alternate, service by alternate means. And then Ms. Langford filed a response, and her response has an address that she's given. Somehow we missed that, so I'm going to make sure that notice gets sent out to that address. You'll get a notice as well. And the next date on this is going to be
March 4th.
March 4th at 9:30 a.m. March 4th, 9:30 a.m.
All right. Thank you, Your Honor.
Thank you, counsel. Good day to you.
Have a good day.
So, I'm gonna send it. So,
Okay.
so let's read notes.
Okay.
Send it to me.
Yep. Oh, that's okay.
This is case number 21-157-339. This is Select Specialist LLC versus City of Detroit. The matter is before the court, set on for a hearing. It looks like while the responsive pleading has been made this matter, it looks like this might be it's not first here. I think so. All right. For the I don't see plaintiff's counsel here, so let's hear from the City of Detroit. Go here in this counsel.
Yes, good morning, Your Honor. Joel Ashton appearing for the city of Detroit, P number 47039.
All right, thank you, Mr. Ashton. So what's updating on what's going on here? Why do I have your information regarding the city of Detroit. I also have on the meeting, I have an address in the home. Should that be in the front? Yeah, I
I'm
have an
having-
address in the volume for you.
That's correct, Your Honor. And I apologize. I'm having some difficulty hearing you on my speaker this morning. I believe we substituted into this. My office is in Livonia. Is that what you're referring to?
Okay, got you. All right, I see what's going on.
That's
Thank you,
correct.
Mr. Adams. So, yeah, go ahead and update me. I know there was a talk of facilitation, sir. Go ahead and update.
There was, Your Honor. We had hoped to have facilitated the case about a week or a week and a half ago. The hearing had to be adjourned. There are multiple parties and related cases involved. We do have a new date of March 9th, and we're hopeful we'll be able to resolve it at that time. Also, my guess is that I believe plaintiff attorney may have believed this wasn't necessary because we had frankly hoped that we'd already have this resolved before today's date, but things got moved back a little bit.
All right, so given that you have a March 9th adjourned facilitation date, I'm gonna go ahead and set it like 2 weeks after that, just to see where we are. Hopefully things get worked out. If not, we'll have a control date. So that's gonna be March.
You said 2 weeks after that?
Yeah.
March 5th, March 2nd.
March 22nd, 3/22, 22, 3/22, 22. And we will set that on at 9:45 a.m. And a notice will be sent out regarding that.
Very good. Thank you, Your Honor. I'll also make sure I let plaintiff counsel know.
All right, thank you, counsel. Appreciate you.
Thank you.
All right, I see that Mr. Salam and Mr. Fry is back regarding the 8316. And counsel, update me on where things are at this point, sir.
Yes, Your Honor. Again, for the record, William Sloom, representing plaintiff. We haven't been able to work out a payment amount, but I think Mr. Fry is aware that if the court does enter the judgment, there's a 21-day period where we don't collect because it's the appeal period. And so he'll be into March anyway. And I've told him, you can contact our office, try to work out a payment plan. If you're unable to, you can always file a motion for installment payments with the court. I believe I don't know if that can be done online or if that has to be done in person, but, and so he has some options there that I think he's aware of.
Yeah, Mr. Fry, you would be able to, obviously you could keep negotiating in terms of trying to reach an agreed upon amount with the plaintiff's attorney office, or you could simply file a petition with the court for partial payments. And once you file that petition, put in there the amount that you believe you can pay, and the court will have to make some decision in that regard. Because of the amount of the judgment, I have to measure the amount of the payment based upon a couple of things. Number one, of course, your resources. Number two, has to do with the amount of the judgment. Obviously, if you owe $1,000, then it's easier to have a small amount as a monthly payment because you only owe $1,000. When the amount is $14,000 or so, then we have to set some reasonable payment based upon the fact that the judgment will likely be accruing interest and so on and so forth. But again, you're entitled to have consideration by the court as to what a reasonable amount is based upon what your resources are, based upon what the amount of the judgment is. And I assure you that if you file such a motion, I will take everything into consideration in terms of trying to set a payment. Mr. Salam's office does that as well. They try to come up with a payment. Obviously, they're speaking from the plaintiff's position, but they would rather have some payment than there would be no payment out there at all. So that sounds like the direction that you you need to go. You have those options to, you can't work out something with their office, then file the motion. It's a motion for partial payments. I will review it, consider it, and make a decision as to what the amount should be. All right,
Okay.
anything else? All right, anything else, Mr. Want to bring to my attention?
Yeah, I was wondering if I could delay this a little bit because, you know, my pension will start coming in March. I'm eligible for my pension as of this month. And that takes, for me to get my paperwork in and start getting my pension, that takes about 45 days. And I'll be able to get my arms around other bills that I owe and be able to come up with a partial payment. So can we come back as we're doing now and then work out a payment with you? I'll talk with Buckles and Buckles as well.
Well, the motion for entry of judgment, this case commenced with this court a year ago, in February last year. And there's been a proper motion regarding this matter. I'm going to go ahead and enter the judgment now. You have 21 days before anything can be done. And if you contact court or their office, you could work out a payment. You can't work out a payment, file a motion with the court. Even if you haven't got your pension funds and don't have the amounts where you could pay significant amounts, put that in motion. Put it in a written motion. There's a form. It's called a motion for partial payments, or petition for partial payments. You can put in there, for example, that I'm anticipating that I'll receive additional income starting such and such a date. At the present time, I can afford to pay this. And then the court will take that into consideration so that you potentially avoid garnishments and things along those lines. So you want to take action after the expiration of 21 days. I will enter the judgment that this time, nothing can be done for at least the next 21 days. Then after that, you can decide which approach you want to take in terms of trying to work out some type of payment arrangement. That's going to be the order of the court. I'm granting the judgment on the motion for summary disposition as the court finds that there is no genuine issue of material fact, and that the judgment should enter at this time as a matter of law. I have received a copy or a proposed judgment for entry in the amount of $14,088.12. The court will enter the judgment at that amount and not entering any amount as a partial payment at this time. But I certainly will anticipate that I'll receive such a petition and I will review it. And I will make a decision as to the amounts that should be paid either in the interim or in the long term based upon the request that's made by Mr. Brock.
Thank you, Your Honor.
Should well be paid to both sides.
Thank you, Judge. Have a good day.
Okay,
Your Honor, you have the judgment. We don't need to submit it.
right. I have the judgment. I just signed the judgment. Done.
Oh, thank you, Judge. Have a good day.
Mr. Friday, we'll send that to you in the mail as well, sir. Thanks, sir. You saw my little notes in the.
Yeah.
Okay.
Mhm.
Yeah, they okay, any questions?
No, I put the stuff in and then I'll just keep them today.
Obviously, you had a good week, sir.
Yes, sir. How you feeling? Got my first shot,
Did you?
first dose.
What do I hear? Serious?
I got Turner.
Took it like a man.
Took it on to the 10, yeah.
What brought that on?
That's the one. That's the one.
The Moderna. I had went to Chicago, Deborah, and we couldn't sit down in a restaurant without having that vaccination card.
Oh, okay.
So I did it upon myself, took it upon myself.
Ah,
Deborah, which one did you get?
the Moderna.
Okay.
You got Pfizer?
I have one.
I got Moderna.
Which one?
You got Pfizer, Judge?
Mhm.
Yeah.
Well, that's
They
good.
got Moderna.
I only remember because that knows the option on that.
I wanted Pfizer, but that's what they had, so that's what I took.
Both of them are the ones, as long as you don't get Johnson.
Oh, I know. I know. But they did say, as long as you get something, you know?
Yeah. But I mean, I think for men, that Johnson, wow. Just a small. Oh, okay. Just a small.